Oh, I'm looking at someone's email account.
Yeah, we're on that back up.
Okay, sorry.
Seventh page. And in particular, let's go down a little bit on this page. Whereas first, the left side that we previously interpreted prevailing party in similar contract provisions to mean the party that prevails in the main action or the main issue. As we go to the right side, then the language near the bottom where it discusses at trial were various claims, et cetera. And in that case, there was a counterclaim that was not prevailed upon. Then the end, who won on these two claims is clear. Then it references that. So
but in this case, it was a take nothing judgment, right?
Correct. The plaintiff did not prevail on its claims, and then the defendant then awarded then attorney's fees based upon it being the prevailing as it defeated the plaintiff's claims. It did, I believe, in fact, have counterclaims as well, but it found it to be the prevailing party. But I think again, the focus is the main action or main issue. And is what we discussed as you look overall in this case, we contend that based upon who sought what and the results, that the prevailing party was THB and not Canterbury.
So the real issue here, obviously, who's the prevailing party? Mr. McCaffrey, I know there was a case you cited too that talked about if there was, I don't remember how it was worded, but something about there was relief granted then or reduction in the amount. And I don't remember exactly how it was worded, but I remember there was a case you cited too. What can you go ahead and share screen that case?
I don't have the actual case all brought up and highlighted, but I can tell you the cases, or I can try to do that if you give me a second. But I mean, there are a couple of cases. The case that was cited actually in the original motion for new trial brief, we also cite to it because they talk about the same general theory, which is in order to determine prevailing party, you look to see how the party's relationship was changed and if it was materially altered. And in this case, it's our perspective that the material alteration was in the favor of Canterbury Cove, because pre-suit, THB was claiming it was owed $370,000. After the suit, the court awarded breach of contract damages in the amount of approximately $60,000.
What case are you citing to?
Yeah, that is Intercontinental Group Partnership versus KB Home Lone Star.
Can you share screen that, Ms. Hayes? Do you have that up?
I believe it's also in the Roar Moose Texas Supreme Court case, Your Honor, and I will bring that up while she's looking at that. But the point is that when you have claims where both sides receive some sort of recovery, the bottom line analysis is what was the relationship between the parties pre-suit and how was it altered. And in this case, there was a claim by THB that it was owed $370,000 in a lien, and the court agreed with Canterbury Cove that the lien was overstated by approximately $125,000. And in addition to that, awarded breach of contract damages for damages that Canterbury Cove.
Hayes, can you share more of this case so I can read more of it?
Absolutely, Your Honor. And it would be attorney's fees under the contract.
Okay, why don't you guys go down a little bit? Okay, here we go. So in short, a plaintiff prevails when actual relief on. Okay. In short, a plaintiff prevails when actual relief on the merits of his claim materially alters a legal relationship between, can you go down a little bit? The parties by modifying the defendant's behavior in a way that directly benefits the plaintiff.
Yeah, and our contention is that's exactly what happened here, is that there was a claim that there was owed almost $400,000 pre-suit. You ruled in the plaintiff's favor on the breach of contract claims as well as the overstated lien claim and reduced the amount owed by 70% roughly. That's a material alteration of the claim. Whether or not the liquidated damages claim for delay damages was granted or not, there was still a significant alteration or material alteration in the relationship of the parties, and the court did not err when it awarded prevailing parties. We made these same arguments at the trial, Your Honor. And,
right. I don't remember
you know,
reading the case before. So Mr. Hayes, do you want to argue why this isn't, I guess there's no cases right on point to talk about a reduction of a lien and whether or not that's a prevailing, makes someone a prevailing party.
Yeah, from our perspective, Your Honor, we've not found anything. There are a number of cases where it's very clear you do not have to win affirmative relief. There's not a net recovery requirement in order to be considered a prevailing party. And in this case, the breach of contract claims that were awarded in favor of the plaintiff substantially reduced and offset the pre-suit claim. So I don't think there's any other way to look at it other than the plaintiff prevailed here.
Response?
Sure. The case that I showed to you that we first looked at, the Woodlands North case, actually cites the Supreme Court case and Intercontinental. And then the discussion follows after that, because in that case, there were claims going both ways. And there's even reference that one side didn't win all of the claims that they had sought. But still, the analysis there is the main action or main issue. The Supreme Court doesn't, the case that is up is not one that there are, you could argue that, each side won on certain issues. But I think the analysis by the court is who won overall in this case. And based upon the numbers and contentions that the court is still awarding a substantial amount to THB and the lien's still enforceable. And the flip side, there is no money going Canterbury's way, and it did not prevail on the lien issue. That the analysis is who won the main action or the main issue. And we contend THB did, and that's the analysis to be used. And that's consistent with a Supreme Court case that we are looking at.
There's no cases on point here. I agree. This is kind of a hard call. This may be something for the Court of Appeals. There's no way you guys can try to work out some kind of agreement, split the baby type of thing where you guys each, maybe instead of, I guess the attorney's fees were 70,000, you're doing 35,000 or something. You know what I mean? Like I'm inclined not to grant the motion for new trial, but I am somewhat concerned this could get reversed on appeal because there isn't anything on point. I will say that, the idea that if you award $1 in damages, that makes you a prevailing party. But if you award $0, that's not a prevailing party. That doesn't seem to be right on point, but I kind of get the idea. Like even if the plaintiff prevails just a little bit, you can get attorney's fees. I don't know. Are there any cases that talk about a pro rata apportionment on something like if you prevail in part that you pro rata split it, or is there any cases like that? I haven't seen any, but
I'm not aware of any case that addresses it like that issue, Your Honor.
Yeah, we didn't find one that went in that manner.
I'm sorry.
Yeah, we didn't find one that looked at the pro rata analysis other than just who won the main action. And I didn't see one where somebody, just because they were plaintiff in a case and under your example, they won $10 of their claim, then they win. Again, the overall view is THB was seeking money and was awarded a substantial amount of money. Yeah, there were some set-offs here, but that's just because Canterbury sued first doesn't then make them in the analysis, if they prevail in any claim, to be the prevailing party.
The Supreme Court uses the standard material alteration of the relationship between the parties. And in this case, there was a relationship between the parties where THB pre-suit was filed a lien that said you owe us $370,000. And that lien, as a result of Canterbury's efforts at trial, was reduced by over 70%. That is a material alteration of the status quo. And so I don't think that there's any way, frankly, that gets reversed, given that this was a bench trial and it's an abuse of discretion standard.
I'm not sure where the 70% comes from. We saw 370 and awarded 246, and there was about 60 or 70,000 of set-off claims for Canterbury when they were seeking over $400,000. And again, I guess the final point is this is a contractual analysis based upon the language in the contract, and that's the analysis of what the Woodlands case.
And if I recall correctly, it's been a while since we tried this. There was nothing in the contract that defined what a prevailing party was, correct?
Correct.
That's right. It's just a standard prevailing party contract clause.
Yeah, I'm not inclined to change it at this point, but I don't think it's unreasonable. I don't think either's argument is unreasonable. Have you guys attempted to settle this, or what is the posture of the case at this point?
We tendered the money for the judgment that was awarded the day after or the day of the entry of the final judgment, and we have tried to communicate, but I've not received any phone calls back.
Well, in any event, that's, again, not the.
I'm not trying to get into settlement discussions. I'm just trying to figure out. I don't know. I mean, Mr. Hayes, just realize that if you go up on appeal and you lose, and that could be additional attorney's fees, your client got a lot of the money back. Anyway, all right.
I'm the client, so.
New trial is denied, but I wish you guys the very best of luck. Okay.
All right. Thank you, Judge.
Thanks, Your Honor. Oh, Your Honor, one other thing before we leave, just so you know, I filed a letter that we had agreed to follow the findings of fact and conclusions of law that were requested. You asked us to file it last Friday, and due to my schedule, there was no way I could get to it. Mr. Hayes graciously agreed to extend it to this Friday.
That's fine.
I've sent them to Scott and Madeline, and so as soon as we get those sorted out between us, we'll upload them to the court.
Yeah,
I think
I'd much rather, as long as you guys aren't going to be complaining to the Court of Appeals about me being late, I'd much rather you guys try to work out any differences and then submit them, even if it's late, than, you know what I mean, than just, as long as I still have plenary power and ability to do it, I don't really care that much about when it's submitted.
But we sort of assume, I assume that was probably the case. I don't have any issue with that. I'm not going to be fussing with Scott about delayed findings or anything like that. So, and I suspect he won't do the same. So
we'll get our responses soon. So we'll have something to you next week, Judge.
Thank you, guys. You guys be safe.
All right. Thank you, Your Honor.
Thank you.
Okay, are both sides here on the Trinity Industry versus Lattimore Materials case?
Yes, sir. Good morning, Judge Hoffman. Charlie Jones with Haynes and Boone for the Trinity parties.
Yes, Your Honor. Matthew Nowak on behalf of the Lattimore Materials Corp. party.
Your Honor, also Carrington Giamatorio, also Haynes and Boone on behalf of Trinity.
Okay, let's proceed.
Judge, I'll begin. This is a joint motion. Mr. Nowak and Haynes and Boone have worked well together to extend the schedule in this case. It's it's just become impractical, the current trial setting and deadlines that we have. The case may have expanded a little bit. We have filed an amended petition recently asserting some similar but varied claims. Mr. Nowak had originally asked for some extra time, and having looked at everything, we think that's appropriate. We submitted an agreed third scheduling order to Your Honor. I can either load that in the chat or email it however you like, whatever's best for Your Honor. There's a related issue, Judge, that we would ask the court for a special setting. This is a complicated case involving a lease of about 226 rail cars. It involves multiple experts across water chemistry, geology, metallurgy. Many of Mr. Nowak's witnesses may reside outside the state. Several of our expert witnesses will reside outside the state. We're thinking, I don't mean to speak for Mr. Nowak, but a seven-day kind of trial. It may be shorter, but we'd rather ask for more and do less than the other way around. So Your Honor can manage the docket accordingly. So we'd ask for a special setting, Judge, sometime September, October, November of this year, if possible. I think both parties would like to get the case resolved in 2022. We continue as we're required to do, to discuss resolution of the case at a lot of different points, but discovery is really just getting going. I think Mr. Nowak's taken a couple of depositions. I know we've taken 2 depositions. There's a lot of discovery left to do, I think, before settlement's going to be really seriously considered. In that causation, the parties are just really far apart on causation. I think that's kind of a critical issue. And so until we get through to expert kind of discovery, I think settlement's going to be difficult to come to. All of that is to say, Judge, we'd appreciate your consideration of our new proposed scheduling order in a special trial setting, so that all of these out-of-town witnesses only have to come in once and do this kind of complicated litigation one time, Your Honor.
So let me just say this. I have no problem with continuing the case. I fully understand. And, the case is not, in the era of COVID, not that old,
Yes,
although it's still not a new case. But the concern I have about special settings are twofold. One is that, as you might imagine, we are completely backed up here with cases. And so in a way that I've never seen since I've been on the bench because of this COVID epidemic. And so we start trials, and then we have trials during certain periods. We don't have trials. We have all these waves of COVID variants. And so what I've been doing lately is I'll be glad to reset it. The issue I have is that, there's been periods of time where I can try cases and I don't have to have social distancing. There are periods of time where I do have to have social distancing. There's a period of time where I can't try cases. And so the way Dallas County has done this, as I'm sure you're aware, is that if we're in orange or yellow or green, we typically do not require social distancing. If we're in red, there have been periods of time where we have been able to try cases, but with social distancing. And so why am I bringing all of this up? If you want a special setting, which I don't have a problem with necessarily, is I'm going to require, in order for you to get a special setting, I can't order you to do a 6-person jury, but if you're willing to agree to a 6-person jury, because I give preference to those types of cases over 12-person jury cases when we have to have social distancing because our courtrooms are just not big enough to do social distancing, then what I've been doing is saying, okay, if when you're set, we're in a period of red COVID threat level, then you would agree to a 6-person jury. If we're not in red, then you would be able to get a 12-person jury. I know you probably have to talk to your clients about that. I'm not trying to pressure you to do anything, but that's the best way I've been able to figure out, is to balance all the different issues that we have right now. I am not saying you don't have a constitutional right to a 12-person jury, and if you want to exercise that, you can. I'm just saying that it puts you behind all the other cases that will agree to a 6-person jury and allow us to do these cases more safely.
I understand that, Your Honor. I do agree. I need to check with my client, although conceptually it makes a lot of sense, and I appreciate that. Perhaps, and I'll be quiet and give Mr. Nowak a chance to speak here. We could get the continuation entered, the third agreed continuation order, and come back, maybe not have to have a hearing, but just inform Your Honor by letter or something if we're okay with the six-person jury.
Let me tell you the only issue with that, I don't have conceptually a problem with that, is that I already have a ton of special settings at this point, and so I need to pick a date. I don't set 2 special settings the same week. And so, and if you're not set as a special setting, then, and someone else comes into, let's say I set you on September 15th or something hypothetically, and then you aren't set on, and it's not a special setting, then I may set a different case that week as a special setting in the interim while you're trying to get this information. And so I would suggest maybe we just reconvene this on Monday for a quick Zoom hearing. If that gives you, I don't know how hard it is for you to talk to your clients, or next Friday or whatever, so we can work this all out. Because if it's not going to be a special setting, then I don't care when you set it, because you probably won't get reached anyway. But if it is a special setting, then I need to really carefully figure out when it's going to be set.
I understand that. I guess my more immediate concern is we do have some hot deadlines coming up, and just generally, I think Mr. Nowak and I are in agreement that we've continued the case, but I just want to make sure the court doesn't have any issue with that, it being your docket, Your Honor.
I have no issue with it. It's just I would suggest doing it this way so we can figure out. So I mean, I'm talking about coming back on Monday, not 3 months from now, but it's up to y'all. I could just reset it, and then, but you may not get a special setting because somebody else might get a special setting.
Your Honor, I think I like the court suggestion. If we go back to our client, obviously I have to ask them. I like the idea of the 6th and the 12th, especially given the COVID situation. So we have the opportunity to go. So I'm fine with, either Monday or next Friday, resetting this just briefly so we can get on the court's docket. My only concern is whatever the special setting date is, I do have other trial dates. So what date we pick, we had put in the scheduling order, I believe September 26th of this year, but I have other trial dates in October and actually out of town arbitrations in October and November. So that's my only concern, whatever date we pick.
Yeah, that's why I would suggest we all talk it through, so I can, you can tell me what your dates are. I can tell you what my dates are. We can figure out something that works for everybody. But how long would it take you to be able to get in contact with your client?
I could get by this afternoon or this weekend, so Monday would work for me.
I can probably do the same, Your Honor, although it might. Mr. Bro, who's lead trial counsel on this, is out of pocket with the family issue this week. So maybe Your Honor has time, maybe Wednesday or Tuesday, just to give us a little breathing room so we get all the information we need.
We could set it Tuesday at 9 a.m. if that works.
I'm free.
And feel free to have your client sign on as well. We have a trial docket that morning over Zoom. It's a bench trial docket. And so if you guys, I'll take care of you guys before that hearing starts if you want.
9 a.m. on Tuesday morning is good for us, Your Honor. I appreciate it.
Okay. Rhonda, go ahead and set that at 9 a.m. on Tuesday morning. Thank you, guys.
But as far as just to be clear, as far as the continuance, generally the court has no issue.
I have no issue with the continuance. It's just if for you get a special setting this year, it's going to need to be agree to a 6-person jury if we're in red, because I can't give you preference over other cases if you're assisted on a 12-person jury, because I probably can't try you anyway.
Thank you, Judge.
Appreciate your time, Judge.
No problem.
Thanks, Steve.
We'll see you next Tuesday.
Thank you, Your Honor.
Thank you, Your Honor.
Are we here on, I'm a little confused, Russ and Ventures versus Phillips. You guys had a summary judgment set for today that you wanted in person, and we kind of did quite a bit to accommodate you, and then you guys canceled the hearing, and now we have a TRO set. Am I understanding that? Mr. Reynolds, you're muted.
Yes, Your Honor, we rescheduled the summary judgment for Monday, February the 7th, because we have competing motions for summary judgment. But this is sort of an emergency superseding event because our TRO that we had in place and extended for until Tuesday, which was the then current trial date, expired, and we could not reach agreement on an extension of it. And so I'm here on a new application for a TRO. And I'm prepared to present our case as quickly as possible. We had a TRO entered on October the 23rd against only Dynesic, Phillips, and Mr. Chafin. By agreement with between Mr. Wiggin and me, we extended that. And then over discovery, we learned of the existence and involvement of Mr. Novicki, ex-med, his and Mr. Phillips' company, and a company called PACT Enterprise. So we amended our petition in November to include those defendants. And Mr. Wiggin is representing both the Dynesic parties and Mr. Novicki, although the company that Mr. Novicki is an owner of, PACT Enterprise, is represented by Mr. Charnitsky. And Your Honor has had several hearings with us on various matters over the last several months. But because Mr. Novicki is an owner of PACT Enterprise, I was content to have Mr. Wiggin extend our TRO to Mr. Novicki as well as to Dynesic. And we had several extensions of that until Mr. Wiggin suggested, let's just put it out to the trial date and not have to keep coming back. So our fourth extension, which is Exhibit D to our application, Your Honor, was the TRO that extended until January 18th, which was our then existing trial date. Now, last December, we agreed on a further extension of the trial date out to September 13th of this year. That's where we are set now, and we extended all discovery and expert designation and pretrial schedules to December the 7th. As I said, I was content for a further extension, although I wanted to add PACT Enterprise, and I didn't hear from Mr. Charnitsky on that, but I heard from Mr. Wiggin, who said he wasn't going to do it. So the TRO we are seeking today is different in the sense that it includes new parties, ex-med and PACT Enterprise, but it also seeks a further restraint on use of our trades, our confidential formula and product. We have causes of action for breach of contract, tortious interference, misappropriation of trade secrets, civil conspiracy, and a declaratory judgment. We're now on our third amended petition and a supplemental petition, which were in place since last year. And we have, I guess, put in this application the evidence that we think from the discovery that we've had that will that satisfies all of the elements of the TRO that we originally got in place, plus what we're seeking now is an injunction against a further use. Your Honor, has Your Honor had a chance to look at the application?
No, I haven't. It was added at the last minute, and so. Well, let me just ask this, Mr. Wiggin, can you not agree just to extend the original TRO? I'm a little unclear why you wouldn't do that.
Well, Your Honor, it's not extendable except by agreement, but the plaintiff has asked for specific performance in this lawsuit and is seeking enforcement of the contract itself. In our motion for summary judgment that you're going to hear in a couple of weeks, you will see that the plaintiff seeking enforcement of the contract And the basis for the TRO is that there are contractual provisions that entitle it to the rights that it's seeking to enforce by TRO. You'll see in our summary judgment that seeking to enforce the contract prohibits the plaintiff from also seeking to avoid its own contractual obligations. In other words, it can't reap the benefits, but not perform its own obligations. And so that is our position. And because the plaintiff has restricted by agreement the scope of their damages to those monies paid under the settlement agreement related to the previous litigation, and that's the agreement they're seeking to enforce, it is my position that the plaintiffs asking for this contract to be enforced is in fact a prohibition against the damages that they're seeking, and therefore we're entitled to summary judgment. I did not find any particular case law on point that would say that us agreeing to continued extension of the TRO would somehow negate that element of our motion for summary judgment. But I didn't find anything to the contrary either. And so we want plaintiffs to affirmatively, plaintiff singular, to affirmatively ask for relief based on the contract, which they're doing now, but they're not entitled to it. We did it as a convenience to avoid expenses of a temporary injunction hearing, not because my clients were doing anything wrong and not because they had engaged in any conduct that was wrongful under the contract. I showed the TRO to my clients back at the time and I said, "Are you doing these things?" "No." And I said, "Well, do you want to pay me to fight against this?" There would be no point in expending the money. And they said, "Well, you know, we'd rather save our money on more contentious issues." But the problem with the TRO that they're asking for today is, as you know, Rule 680 only allows for one 14-day extension unless it's by agreement. And in this case, it's already been extended and there is no further agreement to enter the TRO. The fact that Mr. Reynolds and the plaintiff have called this a new TRO, as it relates to my clients, it's the same relief. And they call it a little bit different. In the original TRO, they say you can't manufacture, use it, etc. But now they're just saying use. But if Your Honor, if I may share my screen, this there's a case called it's a real estate case. Can you see that, Your Honor?
Yes.
So in that case, the judge signed a TRO, signed an extension, and then the real party asked for a new TRO. And the court found that you can't get a new TRO, even if it's a little bit different, if it essentially, if you see at the bottom, if it essentially has the same effect on relator. Well, in respect to my clients, it has the same effect. Mr. Charnitsky can speak on behalf of PAC, but as it relates to my clients, it's the same effect. And the Supreme Court has said you can't get unlimited extensions of a TRO. Otherwise, there'd be no reason to ever seek a temporary injunction, which has more.
You know what, that makes perfect sense. I agree with that. And so what we need to do is a temporary injunction hearing on this,
right,
on agreement. And so why don't we set, I don't have time for that today, so why don't we set that for Tuesday morning?
Well, Your Honor, to the point about we're on a new TRO, and the temporary injunction hearing could grant further relief. I understand that, but we have I don't know whether my clients are available on Tuesday morning. I mean, that's a little urgent. What I was asking for was a TRO that will.
I don't think I can do a new TRO. I think you need to do a temporary injunction at this point. So I would deny the new TRO. I'm trying to fit this in as quickly as I can. If you can't do Tuesday, then we can look for another date. But I can't do a new TRO. I can't just keep granting new TROs for exactly the reason that case said is.
Well, Your Honor, I haven't read that case, but and it's probably distinguishable. I think, because we have done numerous agreements by numerous extensions by agreement. And I had no reason to believe that we wouldn't continue this, but I'm feeling naked for the next however many times it takes to, how many days it takes to get together for a temporary injunction hearing. And I'm worried about it. And I think this new TRO, if it can only last for 14 days, but
I can't just keep granting new you see the issue is that theoretically you could have a judge grant a TRO after TRO after TRO and never get to the injunction phase.
Well, I agree with that, Judge, but the problem is that we have done this by agreement. We haven't had to bother Your Honor at all. This is in effect the first time we've asked since we were originally granted it. And
the TRO is denied. If you want me to, I'm trying to accommodate you. I understand your concern. I'm willing to do it on Tuesday. If you want to check with your client and see if they're available on Tuesday, I can do that.
Well, Mr. Wiegand brought up the fact that we have summary judgment hearings coming up a week from Monday, I think, on February.
Don't have time to do a temporary injunction that day. So
no. I understand that, but I can confer with Mr. Wiegand and Mr. Tarnitsky, and we may. We've already got embedded costs in the summary judgment motions, and the result of those may very well affect the outcome of the case. And we might put the summary judgment, the application for the temporary injunction off till a date beyond that. We haven't talked about that, but we will.
Okay. Thank you, guys. Good to see you, and we'll see you at the summary judgment hearing.
Thank you, Your Honor.
Thank you, Your Honor.